Continuation on certain laws by Legislative Department. Appropriation laws created to regulate spending. Section 22, Article 7, the President shall submit to the Congress within 30 days from the opening of every regular session, as the basis of the General Appropriations Bill, a budget of expenditures and sources of financing, including receipts from existing and proposed revenue measures. Section 24, Article 6, all appropriation, revenue, or tariff bills authorizing increase of the public debt, bills of local application, and private bills shall originate exclusively in the House of Representatives, but the Senate may propose or concur with amendments. Section 25, Article 6, the Congress may not increase the appropriations recommended by the President for the operation of the government as specified in the budget. The form, content, and manner of preparation of the budget shall be prescribed by law. 2. No provisions or enactment shall be embraced in the General Appropriations Bill unless it relates specifically to some particular appropriations therein. Any such provision or enactment shall be limited in its operation to the appropriation to which it relates. 3. The procedure in approving appropriations for the Congress shall strictly follow the procedure for approving appropriations for other departments and agencies. And 4. A special appropriations bill shall specify the purpose for which it is intended, and shall be supported by funds actually available as certified by the National Treasurer, or to be raised by a corresponding revenue proposed therein. 5. No law shall be passed authorizing any transfer of appropriation. Take note. However, the President of the Senate, and the Speaker of the House of Representatives, Chief Justice of the Supreme Court, and the heads of the Constitutional Commissions may by law be authorized to augment any item in the General Appropriations Law for their respective offices from savings of other items of their respective appropriations. 6. Discretionary funds appropriated for particular officials shall be disbursed only for public purposes, to be supported by appropriate vouchers and subject to such guidelines as may be prescribed by law. 7. By the end of any fiscal year, the Congress shall have, if by the end of any fiscal year, the Congress shall have failed to pass the General Appropriations Bill for the ensuing fiscal year, the General Appropriations Law for the preceding fiscal year shall be deemed reenacted and shall remain in force and effect until the General Appropriations Bill is passed by the Congress. Section 29, Article 6. No money shall be paid out of the Treasury except in pursuance of any appropriation made by law. Procedures for passage of bills. Section 27, Article 6. Every bill passed by Congress shall, before it becomes a law, be presented to the President. If he approves the same, he shall sign it. Otherwise, he shall veto it and return the same with his objections to the House where it originated, which shall enter the objections at large in its journal and proceed to reconsider it. If after such reconsideration 2/3 of all the members of such House shall agree to pass the bill, it shall be sent together with the objections to the other House, by which it shall likewise be reconsidered, and if approved by 2/3 of all members of that House, it shall become a law. In such cases, the votes of each House shall be determined by yeas or nays, and the names of the members voting for or against shall be entered in its journal. The President shall communicate his veto of any bill to the House where it originated within 30 days after the date of receipt thereof. Otherwise, it shall become a law as if he had signed it. Generally, there are 3 ways for the bill to become a law. 1. When it is approved by the President. 2. When the vote of the President is overridden by 2/3 vote of all the members of both Houses. 3. Upon failure of the President to veto the bill and return it with his objections to the House where it originated within 30 days after the date of receipt. I'll just skip that part on passage of bill. I guess I already know a little of this. Let's just read it. House rules. Preparation of the bill. 1. The member of the member or the bill drafting division of the Reference and Research Bureau prepares and drafts the bill upon the member's request. 2. First reading. The bill is filed with the Bills and Index Service and the same is numbered and reproduced. 2. 3 days after its filing, the same is included in the order of business for first reading. 3. On third reading, the Secretary General reads the title and number of the bill. The Speaker refers the bill to the appropriate committees. Third, committee consideration or action. 1. The committee where the bill was referred to evaluates it to determine the necessity of conducting public hearings. If the committee finds it necessary to conduct public hearings, it schedules the time thereof, issues public notice, and invites resource persons. If the committee finds that no public hearing is needed, it schedules the bill for committee discussions. 2. Based on the result of the public hearings of the committee discussions, the committee may introduce amendments, consolidate bills on the same subject matter, or propose a substitute bill. Then it prepares the corresponding committee report. The committee approves the committee report and formally transmits the same to the Plenary Affairs Bureau. Fourth, second reading. 1. The committee report is registered and numbered by the Bills and Index Services. It is included in the order of business and referred to the Committee on Rules. 2. The Committee on Rules schedules the bill for reconsideration on second reading. 3. On second reading, the Secretary General reads the number, title, and text of the bill and the following takes place. A. Period of sponsorship and debate. B. Period of amendments. C. Voting, which may be done by 1. Viva voce. 2. Count by tellers. 3. Division of the House. And 4. Nominal voting. Fifth, third reading. 1. Amendments, if any, are engrossed and printed copies of the bill are produced for third reading. 2. The engrossed bill is included in the calendar of bills for third reading and copies of the same are distributed to all members of the 3 days before its third reading. Third reading, the Secretary General reads only the number and title of the bill. A roll call or nominal voting is called, and a member, if he desires, is given 3 minutes to explain his vote. No amendment on the bill is allowed at this stage, so di na mag-amend sa third reading. The bill is approved by an affirmative vote of a majority of the members present. If the bill is disapproved, the same is transmitted to the archives. 6. Transmittal of the proposed bill to the Senate. The approved bill is transmitted to the Senate for its concurrence. 7. The Senate action on approved bill of the House. The bill undergoes the same legislative process in the Senate. So, balik na podcast sa first, second, and third reading. 8. Conference Committee, bicameral. A conference committee is constituted and is composed of members of each House of Congress to settle, reconcile, or thresh out differences or disagreements of any provision of the bill. The Congresses are not limited to reconciling the differences in the bill but may introduce new provisions germane to the subject matter or may report out an entirely new bill on the subject. The Conference Committee prepares a report to be signed by all the conferences and the chairman. The Conference Committee report is submitted for reconsideration and approval of the House on both houses and no amendment is allowed. 9. Transmittal of the bill to the President. Copies of the bill signed by the Senate President and the Speaker of the House of Representatives and certified by both Secretaries of the Senate and the Secretary General of the House are transmitted to the President. 10. Presidential action on the bill. If the bill is approved by the President, the same is assigned an RA number and transmitted to the House where it originated. If the bill is vetoed, the same, together with the message citing the reason for the veto, is transmitted to the House where the bill originated. 11. Action on approved bill. The bill is reproduced and copies are sent to the official Gazette office for publication and distribution to the implementing agencies. It is then included in the annual compilation of acts and resolutions. 12. Action on vetoed bill. The message is included in order of business. If the Congress decides to override the veto, the House and the Senate shall produce separately to reconcile the bill or the vetoed items on the bill. If the bill or its vetoed items is passed by a vote of 2/3 of the members of the House, such bill or item shall become a law. A joint resolution is not a bill, and its passage does not enact the joint resolution to a law, even if it follows the requirements expressly prescribed in the Constitution for enacting a bill into a law. However, a joint resolution can be part of the implementation of a law as provided in the law itself. The joint resolution can also be treated as a recommendation to the executive on how the law can be implemented. Further, neither the rules of the Senate nor the rules of the House of Representatives can amend the Constitution, which recognizes only a bill can become a law. From the case Ang Nars Party List versus Executive Secretary, 2019. Section 26, Article 6. 2. No bill passed by either house shall become a law unless it has passed 3 readings on separate days and printed. Copies thereof in its final form have been distributed to its members 3 days before its passage, except when the President certifies to the necessity of its immediate enactment to meet a public calamity or emergency. Upon the last reading of a bill, no amendment thereto shall be allowed, and the veto thereon shall be taken immediately thereafter, and the yeas and nays entered in the journal. The President's veto power. Section 27, Article 6 defines the only way for the President to veto a bill. When the President vetoes a measure, he should return the measure to the House of Origin, indicating his objections thereto in what is commonly known as a veto message, so that the same may be studied by the members of the possible overriding of his veto. The general rule is, the President must approve a bill in its entirety or disapprove it in toto, except when the bill applies to appropriation, revenue, and tariff bills. Any particular item or items of which may be disapproved without affecting the item or items to which he does not object. Everything else, it's only a matter of yes or no, except when appropriation, revenue, and tariff. If art bills, pwede siya mo veto sa 1 or 2 items. To override a President's veto, at least 2/3 of all members of each house must agree to pass the bill. In such case, the veto is overridden and the bill becomes a law without need of presidential approval. Doctrine of Inappropriate Provision. A provision that is constitutionally inappropriate for an appropriation bill may be singled out for veto even if it's not an appropriation or revenue bill. Exception to the exception. Effectivity of laws. Article 2 of the Civil Code provides that the law shall take effect after 15 days following the completion of its publication in the Official Gazette, unless otherwise provided. This code shall take effect 1 year after such publication. Tanyada versus Tovera, 1985. When the law provides only its own date of effectivity, the publication requirement is mandatory in order that a law may become effective. The object of the publication requirement is to give the general public adequate notice of the various laws which are to regulate their actions and conduct. Without publication, there will be no basis for the application of the maxim, ignorantia leges non excusat. The publication requirement is a requirement of due process. What are the limitations on the legislative power? There are formal and procedural limitations. 1. Prescribes the manner of passing bills and the form which they take. Rider clause. What is a rider clause? Every bill passed by the Congress shall embrace only one subject, which shall be expressed in the title. Section 26 of Section 1, Article 6, rider if delicately related and then EU, in a way or another, wrote on a bill. 2. It's not germane to the purpose of the law. 2. The title is not required to be an index of the contents of the bill. It is sufficient compliance if the title expresses 1. The general subject, and 2. All the provisions of the statute are germane to that subject. from the case of Tio versus Videogram Regulatory Commission 1985. Third, formal procedural limitation is no bill passed by either house shall become a law unless it has passed 3 readings on separate days, provided for under Section 26 subsection 2 Article 6. 4. Printed copies of its final form must have been distributed. Exception. When the President certifies to the necessity of its immediate enactment to meet a public calamity or emergency, the presidential requirement dispenses with the printing requirement, 1, and 2, the requirement for readings on separate days. But in the case of Quida versus Senate, 2001, citing Tolentino versus Secretary of Finance. Substantial limitations. So we have done with the formal limitations or procedural limitations on the legislative power. What are the substantial limitations of such power? Substantial limitations circumscribe both the exercise of the power itself and the allowable subject of legislation. Okay, next part is on electoral tribunals and the Commission on Appointments. Electoral Tribunals. Section 17, Article 6. The Senate and the House of Representatives shall each have an electoral tribunal which shall be the sole judge of all contests relating to election, returns, and qualifications of the respective members. Each electoral tribunal shall be composed of 9 members, 3 of whom shall be justices of the Supreme Court to be designated by the Chief Justice, and the remaining 6 shall be members of the Senate and the House or the House of Representatives, as the case may be, who shall be chosen on the basis of proportional representation from the political parties and the parties or organizations registered under the party list system represented therein. The senior justice and the electoral tribunal shall be its chairman. What are the 2 types of electoral tribunals? We have for the Senate electoral tribunal, set House electoral tribunal, H. Ret. Note, there is a presidential electoral tribunal, but it is governed by different professions. So lain ra ang PET because it's composed of the Supreme Court. The tribunals which have jurisdiction over the question of the qualifications of the President, Vice President, Senators, and members of the House of Representatives was made clear by the Constitution in Poe versus Lemansares versus Comelec 2016. Composition of electoral tribunals. 1. There shall be 3 Supreme Court justices designated by the Chief Justice. The senior justice in the electoral tribunal shall be its chairman. And 2. There shall be 6 members of the Senate or the House, as the case may be, chosen on the basis of proportional representation from parties. Composition rules. 1. The electoral tribunal shall be constituted within 30 days after the Senate and the House shall have been organized with the election of the President and the Speaker, under Section 19, Article 6. Second, members chosen enjoy security of tenure and cannot be removed by mere temporary change of party affiliation, in the case of Bundoc versus Pineda, 1991. What are the valid grounds or just cause for termination of membership to the tribunal? 1. Expiration of congressional term of office. 2. Death or permanent disability. 3. Resignation from political party, which one represents the tribunal. And 4. Removal from office for other valid reasons. Note, disloyalty to party and breach of party discipline are not valid grounds for the expulsion of a member of the tribunal, from the case of Bundoc versus Pineda. What is the nature of electoral tribunal? Jurisdiction. Electoral tribunals are the sole judge of all contests leading to the election, returns, and qualifications of the respective members. When does it acquire jurisdiction? Electoral tribunals has jurisdiction only when 1. There is an electoral contest, and 2. Only after the proclamation of a candidate. In the absence of an election contest, and before proclamation, jurisdiction remains with Comelec. Again, in the absence of an election contest and before proclamation, jurisdiction remains with Comelec. But the proclamation of a congressional candidate knowing the election divests the Comelec of the jurisdiction over the proclaimed representative in favor of each threat. Tanyada versus Comelec, 2013. But see Onshanko Reyes versus Comelec, 2013, where the court held that the electoral tribunal requires or acquires jurisdiction only after 1. A petition is filed before it, and 2. A candidate is already considered a member of the House. To be considered a member, in turn, there must be a concurrence of the following. 1. A valid proclamation. 2. A proper oath. Before the Speaker, A. In open session, B. And third, assumption of office. The court in Untitled Reyes clarified the doctrine that once a proclamation has been made, Comelec's jurisdiction is already lost, and the H-Strat's own jurisdiction only applies in the context of a candidate who has not been proclaimed and sworn in but has assumed office. Election contest. 1. Where a defeated candidate challenges the qualification and claims for himself the seat of a proclaimed winner. Independence of the Electoral Tribunals. Since the Electoral Tribunals are independent constitutional bodies, independent even of the respective houses, neither Congress nor the courts may interfere with procedural matters relating to the functions of the Electoral Tribunals. From McAlindale versus Pett, 2010. Powers of the Electoral Tribunal. The power granted to each strat by the Constitution is intended to be as complete and unimpaired as if it had remained originally in the legislature. Co versus each strat, citing Angara versus Electoral Commission. The Constitution mandates that the House of Representatives shall be the sole judge of all contests relating to election, the returns and qualifications of its members. By employing the word sole, the Constitution is emphatic that the jurisdiction of the H-Strat in the adjudication of election contests involving its members is exclusive and exhaustive. Its exercise of power is intended to be its own, full, complete, and unimpaired. Case of Dueñas Jr. versus H-Strat, 2009. Commission on Appointments, Section 18, Article 6. There shall be a Commission on Appointments consisting of the President of the Senate as ex officio chairman, 12 senators, and 12 members of the House of Representatives elected by each member on the basis of proportional representation from political parties and parties or organizations registered under the party system represented therein. The chairman of the Commission shall not vote, except in cases of a tie. The Commission shall act on all appointments submitted to it within 30 session days of the Congress from their submission. The Commission shall rule by a majority vote of all members. Composition of Commission on Appointments. 1. Senate President as ex officio chairman shall not vote except in a case of a tie. 2. 12 senators. And 3. 12 members of the House of Representatives. Rule on proportional representation. The 12 senators and 12 representatives are elected on the basis of proportional representation from political parties and party-list organizations. The House of Representatives has authority to change its representation in the Commission on Appointment to reflect at any time the changes that may transpire in the political alignment of its membership. It is understood that such changes in membership must be permanent. In the case of Daza versus Singson, 1989. While recording proportional representation in the Commission on Appointments, Section 18, in effect, works as a check on a majority party on the Senate and helps to maintain the balance of power. No party can claim more than what it is entitled to under the rule. Gingona Jr. versus Gonzalez, 1993. What is the nature of Commission on Appointments? Inom sa tag water, please.